Robert, thank you so much for agreeing to take part in our Great Minds series. We're absolutely delighted to have you participate. To our viewers, we'd like to say that Robert West is a partner in the pensions department at Baker McKenzie, the international global law firm. He's a past chairman of the Association of Pension Lawyers and a former non-executive director of the Pensions Advisory Services, and is a current member of legal consultative panels for TPAS and NAPF and LexisNexis. Robert has worked extensively with the UK government for many years in connection with new legislation. He has advised many employers and trustee boards on a range of matters, including corporate benefits restructurings, pension disputes, both in the UK and in the European Court, cross-border issues and de-risking. Can you please start by providing our students and viewers with an overview of Baker McKenzie, the structure of your organisation and the key services that you offer to your clients, please?
Certainly. Baker McKenzie is a pretty unusual organisation, or at least it was when it was first established. It was established immediately after the Second World War, and it was established with the vision of being a global legal practice, which certainly at that time and for many, many years was unique. The organisation spread as a result of organic growth, so not typically by acquisition, and it very much continued in the ethos of being a partnership. So we've grown from the original roots in Chicago in 1949. We established ourselves in London in 1961, and we now have around the world 1,400 partners, total legal staff about 5,500, and we're located in 45 countries and 77 offices in total. It's particularly unusual because we have such a broad base. There are quite a number of international law firms now, but certainly none as broadly spread as Baker McKenzie. And there is a key difference, if you like, between the way that Baker McKenzie grew up and most other firms grew up in terms of advising in other jurisdictions. We tended to follow our clients around the world, and in particular from a initial Chicago base. We found that clients were, say, going to Europe, South America, and so we would be setting up offices there and practicing local law, and so hiring local lawyers, typically training them in our larger offices, London, Chicago, New York, say, and from that it's grown into a very broad organisation, which is a major player in many jurisdictions around the world, as opposed to just being concentrated, say, on financial centres. And in particular, we practice the local law. So I'm an English qualified lawyer. I practice English law. I'm in a global partnership. The global partnership provides advice in all sorts of areas. Certainly in terms of global deals, we're fortunate in London in that English law is the bedrock of many global deals, but the structure is it's a global partnership.
Okay. Next few questions are sector specific. Robert, one of your areas of specialisation is within the pensions industry. What are your views on the governance of final salary schemes, which are now closed to new members and accruals? How may governance be strengthened to work for all beneficiaries of the schemes? So, for example, deferred as well as pensioners in payment.
I think it's a very good question because pensions have developed so much over the course of my career in pensions. From the stage at which originally we had in the UK defined contribution schemes, then defined benefit schemes became the important thing, and so that is pension schemes which promise a benefit which is calculated by reference to an individual's remuneration. So ultimately you're making a pension promise rather than just a savings account. So defined benefit schemes became the big thing. I mean, there had been a lot around from the early part of the last century. I mean, one of my schemes, Merchant Navy scheme in the UK, was set up in 1937, and that's still a big and vibrant scheme. But the problem is that the increasing cost of those schemes over the years has meant that many employers have shut those schemes to new entrants. Many employers have got deficits in their pension schemes, and what happens after a period of time is two things. One is the pension scheme is no longer as central to the organisation as it once was, and you have different kinds of pension scheme coming in, defined contribution schemes, which can be complex but are much more like a kind of global savings account. So you look at defined benefit pension schemes, which in some cases are in run-off, and what you're looking to do is potentially insure them with insurance companies. We did for one of our schemes a couple of years ago, £1.5 billion insurance policy effectively to insure all of the benefits of one sector of that scheme. So you're getting into a position where you're looking for solutions which help companies to contain and identify their long-term cost. Now, to answer your question properly, the difficulty with that, of course, is, or one of the difficulties, is that whereas in years gone by you tended to have major companies with in-house pensions departments who were really clued up in terms of how they were running pension schemes, these days you tend to find that individuals within organisations, notwithstanding the fact that they may have a final salary stroke defined benefit pension scheme, regard that as a little bit of a problem rather than the benefit, and are not steeped in the kind of long-term knowledge of pensions that you would have found in companies 10 or 20 years ago. So the short answer is you do find that the governance is in danger of slipping, and one way that many schemes have found to counter that is there has been a rise in the number of independent professional trustees who are put in place with pensions knowledge and specific experience of a whole array of pension schemes, which can bring proper governance, if you like, to schemes that might be in danger of losing it. There is more regulation. Regulation goes right the way back to the Maxwell days. There is more regulation, but there is also the need for governance on trustee boards. This is a very important and onerous role.
So on that issue of funding, should pension funds be following the example of the Ontario Teacher Scheme and directly, say, invest in infrastructure projects?
It's certainly something, and I've got to declare a certain amount of interest because we do act for Ontario Teachers in scheme in many of their investment projects in the UK. To date, relatively few UK pension schemes have invested in infrastructure projects in their own right. There has been quite a lot of discussion about it over the last 3 or 4 years. I think the slight difficulty is this. A good thing is that pension funds are long-term funds, their liabilities are long-term, and therefore having a long investment in a long-term project is something that pension schemes can certainly contemplate. On the other hand, it's only the very largest of pension schemes in the UK which can afford to take genuine stakes in infrastructure projects to such an extent that they can actually influence the project. So the short answer is there is a greater place for infrastructure, but it's quite a difficult thing for more than, say, the top 50 pension schemes in the UK to contemplate doing on their own.
I think you alluded to this a bit earlier. Obviously, the law on workplace pensions has changed. What are your views on the position that auto-enrolment is leading to a dumbing down of the UK pension sector? It's quite difficult to anticipate how that will happen how that will affect things in the long term. There have been various concerns about dumbing down over the years. The introduction of personal pensions in the 1980s was seen as potentially a dumbing down from defined benefit to defined contribution. Then we had the introduction of stakeholder pensions, and now we have auto-enrolment. And on each occasion, a minimum
tends to be introduced, and there is always a concern that there might be a rush to the bottom and that every employer decides that providing minimum level of benefits is the appropriate thing to do. So far, I haven't seen evidence of that happening, and I think the evidence I have seen is that pensions are becoming more broadly available, not necessarily at a level that will sustain someone's retirement, I might say, but that at least going through the mechanism of auto-enrolment and ensuring that everyone's in a scheme. They can opt out, but opting out happens, but it doesn't happen as much as you might expect. So far, I haven't seen a big erosion. I think what's happened rather more is that employers who've stuck with defined benefit schemes over the years have moved now more to defined contribution, but they're putting in a good quality of defined contribution scheme as opposed to the basic minimum auto-enrolment requirement.
Okay. This brings me on to the final question. If you can give any advice to any of our students and graduates who are thinking about entering the international legal sector, what would this be?
I think first of all, there's getting over the threshold, which is, and sadly, these days, I speak from the days when there was no such thing as a summer internship or placement. There was no such thing as work experience.
Or an Easter vacation scheme.
Or an Easter vacation scheme. And interviews took half an hour, and that was it, whether or not you got a training contract. What's important now is, of course, to be able to demonstrate the academics. The good thing is that firms are casting the net much wider these days, and that's a very, very good thing. But the academics are obviously important as a baseline. Work experience / internships are important, not necessarily in law, but they're important in terms of showing that showing two things really. One is that you've got, if you like, the drive and determination to get them, because these days they're quite often the process for getting an internship can be as demanding as getting a training contract. So first of all, you've shown that you've got the determination to get them, and secondly, actually seeing some other organisations in operation helps you in terms of your commercial feel, and it will also help you to gauge the organisation that is then interviewing you. So that's very important. So that is kind of essential for getting over the threshold, including knowing something about the firm you're applying to, even for the online application, and then little things like your covering letter. We get grammatical issues in covering letters get if you have 3,000 applications, of whom several hundred would meet all apparent criteria, and you've got some unfortunate bits in your covering letter, it will not get past the HR department. Ridiculous though that may sound, criteria have got that process has developed dramatically over the years. So that's one thing to get to help with the application process, but also to get the rounded experience. Though I must say, when I pick up a CV and I see that someone has done nothing over their summer and Easter vacations, nothing other than work in different law firms, I think yes, that's all very commendable. But on the other hand, it's unfortunate that it's come to not being able to go off and
So what I'm hearing is, someone who's focused, a student who actually goes out and tries to make sure that their Easter time, their summertime, any vacation time is worth pursuing in a proper professional sphere, so they get some professional experience before they start applying.
But do maintain a bit of work-life balance.
Yeah, absolutely. On behalf of everyone at the London School of Business and Finance and Global University System, Robert, thank you so much for your time. Thank you.